Welcome back to Courtroom.
And are you Mr. Mishler?
Today's case
Counsel, have you received all discovery? Did you review it with your client?
A defendant faces
Court will
decades of
find
life
that
in
the state
prison
is in
after
compliance
pleading
with
guilty
discovery.
to serious child pornography
Mr.
charges.
Mishler, did you review the true
before
bill
the
of
plea,
indictment with
the
your
courtroom
attorney? Did you
erupted in fierce
understand it?
debate
Yes, ma'am.
over
Counsel, do
bond,
you waive
surveillance footage,
the reading
and a
of the
no-contact
indictment?
order
We do,
protect
Your
the
Honor.
child.
State it
With the
appears from
defendant's
the
future
indictment and the
child's
plea
safety on
paperwork
the
you're
line,
proceeding on.
the judge
counts.
must strike a balance between justice
Right.
and protection.
Counts 1 and
This
10,
is a
Your
case
Honor.
you won't
Thank you.
forget.
All right. So yes.
She did inform us that unfortunately both the worker and the supervisor are both no longer with CPS anymore, and she will not have any other further information she can give us.
All righty. Let's go back on the record. Court is recalling 2025 CR 001961 State versus David Lopez. And I will hear your argument. I'm assuming there are no further witnesses.
That's correct.
All right. And Cindy, for the record, the state has informed the court that the caseworker on the CPS case and the supervisor are no longer employed with CPS. All right. I'll hear argument.
Hi, yes, Your Honor. So the reason the state is asking for the no contact order, one, because in cases like this, these are bond conditions that are typically put in place. That was not put in place. The defendant was arrested out of county and then bonded out. So whoever magistrated him out of county did not put any conditions on. My understanding is that from reviewing the CPS records, yes, CPS did allow the defendant back in the home after these allegations came out, and also after they found reason to believe. And to me, that just does not seem reasonable. And so that is why the state is asking for the no contact order, because the child has been in the home with the defendant and with her mom, for all intents and purposes, who she's been in the home this entire time with the defendant who she says has abused her, and the state cannot adequately analyze their case while the child is still in the home with the defendant.
All right.
Your Honor, if I may please the court. This case, the allegation happened in 2022. The officer did state that he had gathered all the information as he saw fit, but was going to turn it over to the DA, even though the alleged complainant recanted. This case wasn't picked up until March 2025, where CPS had already allowed my client back in the home, and there has been no indication of anything going on since 2023. It has been status quo. He also bonded out on a $100,000 bond from the state's investigation, or from their investigator, which kind of charged him incorrectly. I believe his bond is overly intrusive. I would hate for his bond to be reduced and him to have to rebond out to go through the process, because he's already spent everything he had on the $100,000 bond. They have adequate cameras put in place. Everything has been status quo since. You've heard a very small portion of why the children need supervision at home, also David's supervision at home. He has cameras in all the right places that need be. There are other individuals in the house as well, and I just think it would be overburdensome for my client to have additional conditions that weren't put on until August of 2025, when the state is finally getting ready for this case. We've been ready, well, since March. I'm asking that the bonds remain in effect the way they are until trial, and we'll be ready.
All right. So this is what the court will note for the record. The indictment, and both parties have agreed that the indictment is incorrect, that he does not have a prior conviction. Is that correct?
Yes, Your Honor.
And then the court will note that he's been in the household for this length of time. Both parties have agreed that the witness has recanted. Here's my question for you, because I still, CPS does their investigation. Their investigation is their investigation. I know that you've been in the house for the length of time that you've been in the house. I know that you have cameras up. Question for the court is, will you make those cameras accessible to the DA?
Most definitely, Your Honor.
All right. So if he's going to make sure that the cameras are accessible to you, my understanding, it's an SD card in all of the cameras?
Yes.
All right. How often are you going to want to view the SD card?
Your Honor, I guess it's something I can work out.
All right, if y'all discuss that, but I'm not going to order the no contact order based upon everything, the evidence that the court has heard based upon the indictment being incorrect. If the indictment were correct, this would be easy for the court to make a decision on.
May I ask my client one question?
Sure.
Off the record. Your Honor, it's my understanding that these SD cards record for 30 days. I would say,
Do they ever,
I was going to
is there
say,
any
can we get a,
recording over?
no, I was going to say, can we get a double and have them available for the state every?
If you all will discuss that,
Okay.
how often you want those available, but I'm not going to grant the request for the no contact order based upon the evidence that I'm hearing. But I am going to add the condition that the state is allowed to view the SD cards. And if you all can just come back to me and you all can write it in the order, how often you want those SD cards to be reviewed by you.
I think every case.
All right. So will they be able to turn over the SD cards?
I will have my client buy additional SD cards and then provide them to me, and I will have them available for the state. And then I guess when we give them the next ones, they'll give us those back.
All right. So we're at the end of the month now. So I'm going to want an SD card provided to them before this month is out. And then after today, let me see. So that will, when will you be able to provide that to them? Friday?
Your Honor, I'm stepping into something I don't know. What I'm wondering is if I could provide like a 2 terabyte card and all these SD cards be loaded. That way the same cards can be used and I can constantly have these.
Sure. But my understanding though is, are you going to be able to provide it to them at the end of this month?
I'll take care of that.
Yes,
All
sir.
right.
I will
So,
get more SD cards, and my outdoor cameras have a home base, so it has a 2 terabyte hard drive in it. If you have access to plugging it, I'll take the hard drive out and review it, and then I can put it back in.
all right. So we'll begin with the first date, the end of this week, and then 30 days thereafter.
Yes,
All right. Is there anything else?
not from the state judge.
Nothing from the defense, Your Honor. Thank you
And
for
let me
your
see,
consideration.
does he already? Yes, he's coming back. All right. If there's nothing else, then you will be excused. And thank you for addressing the appropriate court. I'll sign this order and then you will have it.
Thank you, Judge, very much for your
You're welcome.
consideration.
Thank you. Daniel Flores. All right, could a prosecutor take this plea, please? And I'll walk you through the plea. Court is calling 2024 CR 010526-02. Can I have parties announced?
Carissa Chilkowski for Mr. Mishler.
And are you Mr. Mishler?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mishler, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears from the indictment and the plea paperwork, you're proceeding on counts.
Just counts 1 and 10, Your Honor.
All right, thank you.
I apologize.
All right, if we can go off the record for a moment.
Your Honor, just for the record, my name's Andrea Crespo for the state.
I don't have the full indictment because this only has one count.
Yes, ma'am. I'll go ahead and bring that right now.
All right, so you're proceeding on counts 1 and 10?
Yes, Your Honor.
And how many counts?
There are 10 counts total, Your Honor.
All right.
And so we're proceeding on, 1 and.
All right, any objection to the waiver of the other counts?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, did you understand in counts 1 and counts 10, you're charged with possession of child pornography younger than 10 years of age? and possession of child pornography less than 50 videos. And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine, and anywhere from 15 years to 99 years or life imprisonment with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We have, Your Honor. The indictment being finished right now, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
And counsel, you want to announce as well?
Sam Locke, with Ms. Chilkowski representing Troy Mishler.
Mr. Mishler, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I'm so sorry.
So this is State's Exhibit 2, Your Honor, with the motion to seal attached. So that was just defense's copy. So this
All right.
is-
Thank you. All right, we can. Let me re-ask that question because the paperwork has been changed. Do you understand that if you were not a citizen, that based upon these charges and entering into a plea of any of these charges, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes, ma'am.
All right. All right, everyone, if y'all could stop approaching, we're on the record, and I'm trying to focus on this. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? To count 1 in the indictment, how do you plea?
Guilty.
To count 10 in the indictment, how do you plea?
Guilty.
State, any evidence?
Yes, Your Honor. The state moves to admit State's Exhibits 1 and 2 into evidence.
We've reviewed and have no objections, Your Honor.
All right, and with regards to the seal,
State's Exhibit 2, Your Honor, it does have a motion and an order to seal on that record regarding the content of.
all right, any objection to the court signing the motion to seal?
No, Your Honor.
All right, the court will find the motion to seal, which is a part of State's Exhibits 1, and it's listed as State's Exhibit number 2. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of counts 1 and counts 10. This will be set for a PSI and TAP evaluation on October 13th. Is there anything else?
Nothing from defense, Your Honor.
All right, once you sign the reset form, you are excused after you speak with probation.
Thank you.
You're welcome.